Welcome to the Old Capital Real Estate Investing Podcast with Michael Becker and Paul Peebles. During this program, you will hear interviews with real-life successful investors who will share their stories and provide useful advice on how to acquire, finance, and operate apartment complexes. Now, here they are, Michael Becker and Paul Peebles.
Welcome to the Old Capital Real Estate Investing Podcast. I'm your host, Paul Peebles, National Underwriter for Old Capital, and joining me today, as always, Michael Becker.
Hey, Paul.
So, Michael, what's going on in the Old Capital world these days?
Well, the next thing we have coming up that we've talked about a few times is getting close is the next Old Capital Speaker Series on March 28th. It's going to be Dr. Mark Dotzauer. He's the former chief economist for Texas A&M Real Estate Center, and that'll be at the Grapevine Convention Center. Doors open at 6, and I think the presentation will start about 7. It'll be, hour and 15 minutes, something like that. So if you definitely want to attend that. The first time I heard Dr. Dotzauer speak, it cost me over $100 to go hear him speak, and so we're going to offer this free thanks to Paul here. He's going to subsidize it. So definitely go to oldcapitalpodcast.com. You can find information about that. That's on March 28th. And then save the date on September 13th. We're going to have the next Old Capital Speaker Series. That's going to be at the AT&T Stadium where the Cowboys play. That's on September the 13th. It's going to be an all-day event, and that one is not free, but we do have tickets available for sale also on oldcapitalpodcast.com. You can find a link for it there. Then the prices will go up. So this is the cheapest you're going to find a ticket. So if you want to go, it's going to be a great event. We'll have all the major brokers in town that sell B and C multifamily will be there, as well as management companies and a bunch of other investors. So it's going to be great networking. Good place to learn a bunch. That's on September 13th. You can find information at oldcapitalpodcast.com.
Some great information. And again, Dr. Dotzauer, he is somebody to go see. He's probably one of the funniest economists, but it really brings it down to the bottom layer shelf, kind of having everybody understand a little bit about what's going on. And it's just not going to be Texas commercial real estate, but it's on a national basis. So make sure you go listen to Dr. Dotzauer. In the podcast today, we have a contracts attorney, somebody that does contractual business. This is somebody that you want to spend some time with probably before you enter into a purchase sale agreement. This is somebody you want to have a relationship with, somebody that is going to be knowledgeable to support your team. They are an integral team member on your team to buy an apartment building. So in the podcast today, attorney here in the Dallas-Fort Worth area, we have Brian Hammer. Brian, thanks for coming into the show.
Thank you, Paul. I appreciate you inviting me to be here.
No problem. Let's kind of get a little bit more background on Brian. Where are you from, Brian, and what's your background?
Well, I grew up in a small town in Texas, went to undergrad at Texas A&M where I majored in economics, then went to law school out at Texas Tech and actually did the joint degree program. So I have my law degree and my MBA from Texas Tech.
Smart guy.
Yeah. So how long have you been practicing law, and kind of maybe talk a little bit about your background, your specialty, and what you practice?
You bet. So I have been practicing coming up on 20 years now, 19 years. I'm a transactional attorney, and so I specialize in primarily 3 areas of transactional law: commercial real estate, M&A work, which is buying and selling businesses, and then just general business contract law, be it setting up entities, reviewing agreements, those types of things.
And Brian and I have done a number of transactions together, and I have found him to be a very straightforward attorney. And any information that Brian talks about today is really just for education. It's not legal advice. So we want to throw that out there right from the beginning.
I appreciate that. That's correct.
Most of the people listening to the podcast either own apartments or aspiring apartment owners or commercial real estate in general. So maybe we kind of talk through the life cycle of a transaction, maybe talk about some of the major components and some things that you look at when you're either reviewing a contract, forming an ND, things along that nature. Maybe kind of start first and foremost kind of with the title commitment, title review. So when you're looking to buy a property, the seller of the property is going to give you a title commitment from a title company that's going to issue the title policy. Ultimately, what are some of the things that you should think about either as a seller or a buyer as it relates to title?
That's exactly right. So while every real estate transaction is unique, which is what makes real estate fun, most purchase and sale agreements cover the same general categories. And then there are some obviously go into more detail than others. But almost every purchase and sale agreement is going to provide for a title commitment. And a title commitment is a commitment for insurance. Texas doesn't follow the Alta policies like most states do. We have our own Texas form title insurance that is promulgated by the Texas Department of Insurance. The purchase contract will typically provide for the seller to provide the purchaser with a title commitment and then a title review period in which the purchaser can review that title commitment and make title objections. And that's a real important process. In fact, it's just as important as any other part of the due diligence process that a buyer needs to look at. The title commitment is going to reflect exceptions to the coverage that the ultimate insurance title policy will provide. And a buyer is going to need to evaluate those, make sure that there is not anything that materially or adversely impacts the buyer's anticipated use of the property or the value of the property. And also, oftentimes the Schedule B exceptions, which is where the exceptions to the coverage are listed, will have items that simply don't apply anymore. And so by reviewing those during the title review process and making title objections, the purchaser is able to expand the coverage that he or she will ultimately receive on their title policy.
So what does that mean in English? What are some of the common things that that would be something that you would want to object to when you review a title commitment? And then how does that relate to, say, nationally with the Alta coverage that you talked about, maybe some of the differences in Texas? So the first thing, what are some of the common things that you might see?
So a common thing that you may see are easements that don't actually impact your property. Another thing that oftentimes on multifamily properties shows up is laundry leases that are no longer in effect. All of those things you can usually resolve during the title review process by making objections, working with the title company, and having those items removed.
So if I have an old laundry contract or maybe two laundry contracts on this property, one that's expired, one that's current, you make an objection and the title company were to get a release.
That's exactly right.
Okay.
That's exactly right.
And then so how does Texas differ versus the Alta process? What are some of is it pretty similar overall, or what's
they're similar. So you're absolutely, if you're used to having reviewed Alta title commitments and title policies, you're going to recognize a Texas policy. They're certainly similar. The Alta policy uses a Schedule B1 and a Schedule B2. In Texas, we use a Schedule A, Schedule B, Schedule C, Schedule C. So they don't track exactly, but they track closely. Some of the endorsements aren't identical. If you're used to buying properties in an Alta state, you would recognize the commitment you receive in Texas.
So one of the other things on top of the title that I don't, as a layman, as just a person that does transactions, I never really fully understand exactly what's going on the title commitment. So obviously rely on the lawyer. The other thing is a survey. So, I mean, we get surveys. Either the seller will provide a survey when you do the deal and then sign an affidavit that we can rely on that survey, and or we'll do a new survey when we do transactions. So maybe kind of talk about that. What are some of the things you look at when you look at a survey, and how does that interact with the title commitment?
Absolutely. So ideally, you're going to be reviewing the survey and the title commitment together. So for example, if the title commitment lists on Schedule B an easement, you would then move to the survey and see where that easement is, make sure that you don't have some of the improvements encroaching over the easement, those types of things. And you're right, on multifamily transactions in particular, a lot of times the buyer likes to rely on the seller's existing survey. And we can usually work with the lender to do that, so long as the title company will provide the survey coverage on the title policy. So one of the things that buyers need to be on the lookout for when they are wanting to rely on the seller's existing survey is to provide in the purchase contract that in addition to receiving a copy of the seller's existing survey, that the seller will provide a survey affidavit. The title company will require that in order to rely on the existing survey for providing the survey coverage.
And basically the affidavit is the seller is going to certify there's no material change of the building or structure's footprints to what's on the existing survey. Is that accurate?
That is correct.
Yeah, cool. So then one of the other things too was, as far as you talk about easements go, what are some of the things that you're specifically looking for? So like one of the common things is it's either, I hear it referred to as non-conforming, either zoning and or you might have a building across the setback line. What are some of the common things that you identify that you typically kind of work around when it comes to survey and setbacks and easements and things like that?
So the non-conforming is one that often comes up, particularly on older multifamily properties, because what has oftentimes happened is the property was built prior to the current zoning regulations going into effect covering the property. So using that as the example, the buildings may be 15 feet from the frontage road, but the current zoning regulation says they have to be set back 30 feet. And so that property is then historical non-conforming, but that is something that the buyer wants to confirm, in fact, that the property does qualify as historical non-conforming during the due diligence period and title review period.
One of the next things, obviously, that you have to do when you put these things together is you'll have some sort of earnest money. Anymore today, a portion, if not all of that earnest money becomes non-refundable either at the execution of the contract or shortly thereafter. What are some of the things that you look at when you're looking through the earnest money part of the contract, and then even further into the due diligence period? Maybe those two kind of go hand in hand. Talk about those sections of the contract.
Certainly. The earnest money from the seller's perspective is primarily to show a confirmation of the buyer's interest in the property, perhaps its financial strength, and then typically it also serves as the liquidated damages in the event of a buyer default in the default section of the contract. And you are right that in a hot market like we have had in Texas for a number of years now, the earnest money, or at least a portion of the earnest money, is often non-refundable. So from the buyer's perspective, if we are going to have non-refundable earnest money from the start, you're going to want to keep that in mind when we get to the reps and warranties section, because you may want some more assurances with respect to the property and the reps and warranties. And also, one of the important things for the buyer to keep in mind is most buyers, even when the earnest money is intended to be non-refundable from the start, expect to receive back the earnest money in the event of a casualty event, in the event perhaps of title defects that are non-cured, but those need to specifically be included in the purchase agreement. Otherwise, the earnest money may be at risk even if those events occur.
Let's talk a little bit about the casualty clauses right now. What happens if like Les is in the middle of a transaction right now, a little 32-unit building, purchase sale agreement was signed, everything's ready to go. We're about to bring it to the lender. All of a sudden, 6 out of the 32 units had a fire in it with smoke damage. There's a claim that was filed for $260,000 on the property. So who gets the money? How do I get out of the deal? Do I want to stay in the deal? What part of the contract kind of leads that part of the discussion?
Just about every contract is going to have a clause that is either titled risk of loss or casualty and condemnation. And so in that event, most of the time the parties will have negotiated what happens if there is a casualty, a fire, or we obviously live in Texas where we can have some severe weather. So if there is a major hailstorm that ruins all the roofs, those types of events are going to be covered by the casualty clause. And most casualty clauses provide that in the event that the damage is non-material, which is typically defined in the contract as a dollar amount, then the parties agree to proceed with the closing. The seller will assign the insurance proceeds to the buyer, typically will give the buyer a credit for the amount of the deductible. Thank you. The deductible, and the parties proceed. If it is greater than that threshold, then usually the buyer has the option of either terminating the contract or proceeding with the contract, taking an assignment of the insurance proceeds and getting a credit for the deductible. One of the things to be on the lookout for, though, for a buyer, or a few things to be on the lookout for the buyer in the casualty clause, are what happens in the event the insurance proceeds are not assignable. Another one is what happens if your lender is no longer willing to provide the loan due to the casualty event. And so both of those items are things to keep in mind when looking at casualty clauses. Typically, that's one of the clauses that people read through quickly because they don't think it's going to happen to them. But when it does, you want to make sure you know what's in there.
Mike, has that happened to you?
Yeah, so that's something that firsthand experience has taught me that is important. Quick story, we had a property. It was the largest property at the time, about $28 million purchase. And We had at that point, I think, almost $1 million of earnest money up. I mean, there was $500,000 earnest money. Then we rate locked our loan for over another $500,000. So we were north of $1 million in this deal. And 23 hours after we rate locked, we had a fire, burn down 8 units of 300 some odd. So that was a fun day when you see your property on the news, and not for the good way. So we quickly learned about the casualty clause, and what we ended up finding out was, I think it was upwards of like 8 or 10% of the purchase price had to be the loss before it became material and we could potentially get out of the deal. And so that was a scary day, but we ended up getting the insurance proceeds assigned, credited the deductible, and then we fought it out for a year and a half to get the building rebuilt and our money paid. So that's something to pay attention to for sure.
And that does happen on fire damages. So when you're going through a purchase sale agreement and you've already signed everything, you think that all the repairs are going to be made within the next 48 hours or even 4 weeks or so. Mike, how long again did it take you to
Yeah, so then you throw the city, depending, every city's a little different, and the city this building was in was a little bit more challenging, and so it just kind of drug out. It took us almost a year to get the building rebuilt and back online, and then took us another 6 months past that to get all our money back from the seller's insurance, because there's a large seller and they pulled it, and we had 5 different carriers, and it was just this whole mess. So pay attention to that. Make sure your limits, the casualty limits, are reasonable and acceptable. That if it's a whole building that burns down, that might be a threshold you want to get out of the deal. These are all negotiated business points in the transactions.
Sophisticated sellers usually push
those limits up higher, and less sophisticated sellers don't pay attention to it, so you can get that a little bit lower. So pay attention to that. That was something I learned firsthand for sure. And make sure that you understand what the coverage of the seller's policy is as well. Make sure they have like ordinance coverage, where if you have to go back and rebuild and put a riser room and sprinkler system to rebuild in the city, that is covered in their policy as well. So the less sophisticated the seller, the less likely, or the more likely they have some gaps in their insurance that you would then be taking an assignment of. So,
and Mike, this is just an aside deal. Is that when you go onto these properties with some of your due diligence folks, and they want to get up on the roofs or so, some of the sellers, insurance companies do not want to have foreign people up on the roof. How do you handle that?
So when you have your people inspect, they have to provide a proof of their insurance, basically, and make sure they name that the seller, and usually seller's management company, are named, and then provide them an insurance certificate to even get access to inspect the properties. So way off topic, but that's maybe back to the due diligence part of it. We didn't talk a lot about that. So when we talk about due diligence, most of what people think about are the physical due diligence, which they typically do on their own or have their management company. So that's checking all the units, the roofs, like Paul mentioned, the sewer system. But what about the legal due diligence? What are some of the things that you, as a lawyer representing clients, what do you do from a legal due diligence standpoint to make sure that everything's in order and you're ready to proceed forward?
Absolutely. And so due diligence is another one that is important. Typically, the due diligence clause is going to give the buyer a specified period of time in which to do its due diligence and then make a decision whether to terminate the contract or proceed. During that time, the buyer will often be doing the physical due diligence. Often the buyer should be also doing a lease audit, verifying the financials, those types of things. From the legal side, what we are typically doing during that time is our title and survey review. We also will be available to consult the buyer when issues come up that maybe the buyer hasn't seen or that are maybe inconsistent with the information that the buyer was expecting to receive based on the contract, and try to find a solution for how the process works. Most of the buyers that are going to be using financing for the transaction will have the lender provide a PZR report or some type of zoning compliance report. I always like to see that so that we can also confirm that it matches what we would expect to see for the property in this location.
So zoning reports, that's something that probably a lot of less sophisticated buyers think about. So make sure you get it, that what the current zoning is. And if the zoning is non-conforming, it could potentially impact the ability to rebuild in the event of a fire. So if it was multifamily time is built, but now is zoned something different, the city might not give you permits to rebuild in the event of a major loss, maybe 50% of the leasable square footage or more.
That's happened to me on a couple transactions where they could not rebuild in case of a fire or a tornado going through. It had just changed the zoning from multifamily into X, and lender didn't like X.
Yeah, and so especially on these agency type loans where there's large prepayment penalties, that could cause some issues. So think about that. The other thing that we do now that we didn't do at the first is we also will go do open record searches with the cities to make sure if there's any sort of crime or fire violations or police records or building violations. We always try to get a copy of the most recent city inspection as well, and just kind of you want to make sure if you're walking into a hornet's nest, you know it, and you have a plan in place to deal with the city, because these cities can impact your operations once you get into it, and that's stuff you don't think about when you first get into this business, but it's things that we do.
I think those are all great points, and one of the things that I recommend to my clients, and I am sure you do this already, Mike, is you have a pretty thorough due diligence list. And so you can ask for many of the things you just referenced for the seller's copies of those. And crime reports is a perfect example. Those are nice things to know. If the seller doesn't provide it to you, you can usually obtain that from the local police department, but those are the types of things that are nice to work off of. A thorough due diligence list is nice to work off of during the process.
And you can get a copy of our sample due diligence checklist by going to oldcapitalpodcast.com. That's certainly something that it's our Christmas list that we ask for on every deal. And we don't always get everything, but it's a pretty comprehensive list. If you guys want to go check that out at oldcapitalpodcast.com, it's a sample due diligence checklist there. So we briefly touched on financing contingency. That is basically just a period within the contract that the buyer has the right to obtain financing, and if they don't get this financing with a minimum loan amount and kind of maximum interest rate, they could potentially get out. Is there anything else you want to add to that that's less common today than what it used to be?
Well, just that the financing contingencies overall are less common today than what they have been in the past, particularly on multifamily transactions. So a buyer oftentimes is going to need to be prepared to move quickly on financing. Historically, I think that there was a due diligence period under a contract, and then also a separate and distinct and oftentimes longer financing contingency. But I find that to be the case on less deals during the hot market.
One of the things that's still a little bit of a mystery, I understand it, but I don't know if I truly do, is reps and warranties. So all these contracts, these are just things that either the buyer or the seller makes either certain representations or warranties that these things are true, or they will do certain things. So maybe kind of talk about both things that a buyer you want to look at for the seller, and then vice versa, some of the things that the buyers are responsible to do in these contracts.
Absolutely. The reps and warranties are the intersection of where the purchaser's desire to have assurances as to what the purchaser is purchasing and the seller's desire to limit its liability intersect. So that is one of the provisions that is often heavily negotiated during the purchase and sell agreement process. From a buyer's perspective, oftentimes the representations and warranties can be used as an assistance to the due diligence. So, for example, you can ask a representation and warranty from the seller that the seller hasn't received any notices of code violations in the last 24 months. If the seller tells you they can't provide that, then now you know that probably there has been a code violation in the last 24 months, and that's something that you're going to want to look into and investigate during your due diligence period. The seller, on the other hand, usually is pushing to have this be a true as is, where is deal. Most sellers will give a representation as to the accuracy of the rent roll, that they aren't aware of any current violations on the property that are uncured, and that they have authority and capacity to enter into the contract. But beyond that is pretty much a negotiation.
So what are some of the common things that you see that buyers that don't necessarily push for that you really always try to get in there in and above what you just mentioned?
Well, the ones I always like to know are there current violations of the property that haven't been cured? The code one I mentioned, a lot of these properties are going to be subject to restrictive covenants. And so it's nice to know, are there restrictive covenants that the property is currently in violation of? I like to have a representation in there that there will be no mechanics liens for unpaid mechanics or materialmen at closing. And then the rent roll, the no lease defaults. There are a laundry list of representations and warranties that, in my experience, when asked for, the seller will usually give, even if the seller wants to limit some of those to the seller's knowledge.
So operating covenants, that's another thing. Paul talks about how you get this deal in contract, it's 95%, and then all of a sudden the deal goes in the tank, and then we're having a hard time producing loan proceeds at the same place we apped it because the occupancy and revenue trends are in the tank. Talk through some of the customary operating covenants that you typically get in deals, and then what is kind of on the Christmas list of things that you want to get in deals if you're representing a buyer.
Absolutely. So the operating covenants are the operations of the seller of the property for the period from the date the contract is signed through the closing date. So those are what are globally referred to as the operating covenants. The typical operating covenants that most sellers will agree to are that they will continue to operate the property in accordance with their historical standards, that they will continue to maintain the insurance on the property that they have in effect as of the effective date, and that they won't enter into any new service contracts that are not terminable at closing. From the buyer's perspective, what we try to get on our Christmas list would be items like that they are going to agree to maintain a certain occupancy threshold, and if they don't, perhaps there's an automatic extension of the closing date, because that directly impacts the buyer's ability to obtain financing.
So what I also see too is that right now, without having a financing contingency in there, we have lots of hard money at risk, whether it's $100,000 to $400,000. In fact, I just had that conversation this morning with the buyer out of California buying a property here in the Texas market. My always concern is that just like what Mike says, the market goes soft or they take their foot off the gas during that period of time. I think as a prudent lender, now, we brought that transaction to Fannie Mae, but with the numbers that actually had gone down from December to January to February, we lost $500,000 in proceeds. If we close it next month, we'd lose $1 million worth of proceeds. As a prudent lender, you pretty much always have to have a backup. So if Fannie Mae decides to cut the proceeds of the transaction because the seller does not operate the property efficiently, doesn't honor its rules of operating on the deal, you always have to have a backup. And so on this transaction, we kind of avoided having to use the backup, but we had the backup ready to go with a bridge loan in case the Fannie Mae transaction was not going to be able to go through.
It's always a good idea to have a plan B. Another operating covenant that's particular to multifamily that it is nice to have included is making units rent ready that become vacant.
Yeah, and then if they don't, so if they produce vacant units and they aren't rent ready, there's $500 or $1,000 as a credit that the seller will give the buyer for everyone that's not rent ready.
That's right.
And then so that's a good idea to schedule a walkthrough of all the vacant units, maybe a day or two before closing, so you make sure you get that credit on your settlement statement. That's a pretty common thing that I've seen in many contracts as well. Speaking of contracts, getting towards the end here, service contracts. That's another thing. Maybe talk through the contracts and what are some of the things that you look at and what's important to when you're reviewing the service contracts, either trash or laundry or cable or electric, whatever it might be. What are some of the things that you look for and recommend that your clients pay attention to?
From the buyer's perspective, what we're really looking for is which contracts is the buyer going to be locked into versus which contracts can we have the seller terminate if the buyer doesn't believe that they are beneficial to the property. On multifamily properties, the typical contracts that can't be terminated, or the most typical contract that can't be terminated, is the laundry lease. Those contracts are usually long-term leases and they run with the land, meaning that when the property is sold, the buyer remains subject to the laundry lease for the rest of the existing terms. Other leases that also similarly can at times not be terminated are electricity contracts, waste management contracts, and those can be beneficial to the property. For example, if there's an electricity contract that has a below market rate, that can actually be a value add, but the buyer is going to want to consider those during the contract process.
And cable contracts are another thing that typically run with the land. And the one thing to make sure when you're reviewing it, so if you have to assume it, again, this is negotiating a business point, but if there's a big, large upfront bonus paid, and that's typical on both laundry and cable contracts, where they can get tens of thousands of dollars sellers for signing a lease, you want to make sure if they just got a big bonus and there's, it's a 10-year contract and you're about 6 or 12 months into it, you get prorated some of that bonus on the front end of the deal. I can tell you a perfect example of when we sold a deal and we were able to sign a big bonus and then we sold it 6 months later. We got the bonus and they got the contract. So pay attention to that. That's happened on the other end of it as well. You're not always successful in getting that negotiated, but that's something that we always strive to get when we're looking at these deals.
Talk a little bit more about these laundry leases. As Mike knows, the laundry leases,
Mafia.
laundry leases and roaches will be the only thing left standing after a nuclear war. So, but the laundry leases are typically 10 years in this marketplace, and you have a 60 to a 90-day window that if you want to cancel out that laundry lease, you have to let them know in writing. Is that true?
That is correct. They are usually 10-year leases and then oftentimes renew automatically unless the owner of the property provides written notice. And the laundry lease companies like to have as small a window as possible for that written notice to be delivered.
So make sure you pay attention to that and make sure that that's a big predominant piece on your calendar, whether it's 7 years or 6 years or 5 years from now, to make sure that that window is someplace in your calendar that you can take a look at. Because again, Brian's right, is that if you miss it, you'll miss a bonus opportunity or you miss the opportunity to cancel that contract. And that's kind of the only way that you can unwind that contract from the property itself.
The next thing, kind of getting at the bottom of my list I had here, was prorations. Talk through that. So common things that the buyers and sellers prorate based on the number of days left in the year or in that month would be rent, taxes, any sort of utility bill backs, utility bills. Those are some of the things. So what do you look for when going through the proration section of the contract?
Right. So you just hit on the big items that are typically prorated on the closing statement under the contract. One of the things from the buyer's perspective that I look for is who is going to be treated as the owner for the day of closing. It's always nice for that to be defined in the purchase contract. On the rents, I want to be prorating rents based upon actually collected rents. I don't want to be having to credit the seller with rent that the seller hasn't collected for the month of closing. And then the other thing that I often see come up that hasn't properly been considered in the purchase and sell agreement on transactions where I've been brought in after the purchase and sell agreement has already been executed are RUBS prorations. That is ratio utility billing system. Thank you for that, which is basically a way for the property to bill back utilities to the tenants upon a sharing ratio, but those are done in arrears. And so unless the parties have addressed that in the purchase contract, I see that often as an issue of negotiation at the closing table as to who owes a credit to whom.
And then true ups as well. So all these are estimates, and after 30, 60, 90 days post-close, there's generally some form of true up where if, the estimates were off either in the buyer's or the seller's favor, there's a true up period in most contracts, but not all, right?
That's right.
Some could be final on the closing statement. So just make sure you pay attention to what your obligation is. And then taxes are a big one as well, where if you sell a property in, say, around April, so next month you sell a property in Texas, they notice on May 1st the new value. So you'd be prorating off of last year's value, and the value could go up, and it could take a while to actually settle it out. So just make sure you pay attention to the true up section as well. And then finally, what happens if you're a buyer and you're trying to buy a property and there's some sort of seller default and you close on the deal? What are some of the remedies either kind of prior to closing or post closing, and some of the caps on damages? Maybe kind of talk through that section as well.
Sure. So under the purchase and sell agreement, the standard remedies in Texas for a buyer default, so the seller's remedy will usually be to terminate the contract, retain the earnest money as liquidated damages, and the parties then go on their separate way. One thing to keep in mind, though, for the buyer on that remedy is that if that is listed as a remedy in the contract, but it doesn't state that that's the sole remedy in the contract, Texas courts have held that that is just listed as one of the remedies, but that the seller would have all other remedies available at law or in equity, even if that really wasn't the party's intent. So that's something to keep in mind on that remedy. From the buyer's perspective, the buyer's typical remedies in Texas are to terminate the contract, receive a return of the earnest money, or to file a lawsuit seeking specific performance. On the first option there, I see a growing trend that where the buyer terminates the contract and receives a return of its earnest money, which, keep in mind, that's the buyer's own earnest money. So basically the buyer's getting back its money. The buyer often also has a right to recover its costs, third-party costs actually expended up to some amount of cap.
So your inspections, your lender application, your lawyer's bill that you accrued up to a cap, that's typically the damages you're referring to.
That's correct.
And that does happen. If you remember back in one of our podcasts, back probably about 6 months ago, we had a buyer on there where the seller defaulted because they forgot they had a large prepayment penalty. And we worked through the entire transaction. The buyer was ready to close. The loan papers were at the closing table. All of a sudden, when they were asking for their payoff, they found out that the loan that they had taken back 18 months ago was a CMBS loan that had a lockout provision, which means they could not sell the property. And that if they were going to wait for another 6 months or so, then they could sell it, but they would have a serious defeasance penalty, a prepayment penalty on it. So they had to unwind the transaction. And that went with a large lawsuit at that period of time where the buyer still wanted to buy the property. The seller said, hey, listen, I'm taking my marbles. And the buyer said, no. You know, here's a summons. We're going to go to court on this deal. So that does happen. So just know that, you know, it's just not only buyers default, but also sellers can default too. So always make sure that when you talk with the seller's agent, that the seller has the right to sell the property up front just to protect yourself.
Yeah. So was there any, we went through a whole bunch of stuff here. Brian, is there anything else that you could think of that we haven't really touched on, or some sort of tips if you're kind of a first time or aspiring syndicator to think about when you're putting a contract together? Because this is a big, scary 50, 60 page document with a bunch of attachments to that. Any other parting thoughts?
Well, just that it is important to use an attorney that actually has some experience in working on purchase and sale agreements for real estate, preferably real estate located in Texas if the person you're referring to is buying a property here in Texas. They are complicated and they matter. So every buyer should take the purchase and sale agreement negotiation seriously. I always recommend that each client review and read every word of the agreement. I know it can put a bunch of people to sleep, but it's worth doing that.
And you just don't want to get into a purchase sale agreement first and then get it signed and executed and then contact your attorney. You want to have your attorney right in the front side. So build a relationship with your contracts attorney. And just like what Brian was saying is that, you know, contracts attorney, they're kind of specialists. There's all different types of attorneys out there, whether they're SEC attorneys or they're attorneys that work on different types of litigation. But it's a specialty that you want to seek out a contracts attorney, especially a real estate contracts attorney that knows the information. So make sure you build your team with a competent real estate attorney up front. Do you recommend a promulgated real estate contract in the state of Texas or the state of Oklahoma or the state of California on the commercial side? Or do you think you should build, or why would you build your own real estate purchase sale agreement?
Well, I actually like to build our own real estate purchase and sale agreement. Texas actually has pretty good promulgated forms. The problem with any promulgated form is that it is intended to be a Swiss Army knife because it is intended to cover all types of purchases. Even if it's a commercial real estate contract, it's intended to cover office buildings, shopping centers, multifamily. And because real estate is unique, which, as I said at the beginning, is one of the things that makes it fun, it is usually preferable to go ahead and structure a contract for the particular transaction.
Yeah, that's what I found. A time or two we've been forced to use the promulgated form because the seller didn't want to pay for a legal bill, and ended up causing us a lot more legal bills on our end because we had to then try to write all these addendums to it and exhibits to it to try to undo some of the stuff like getting a SNDA on all your leases, which is not common when you do an apartment complex, but it is if you buy a retail strip center. So those are just some of the things to think about, and it's probably pretty common whatever state you're in. I don't have a whole lot more, Paul.
Anything else, Brian, that we should be talking about that, newbies who have never really gotten into multifamily, or some people that maybe they've gone through their first little small apartment building or moving into their second or third one? I think we went through a laundry list of things to watch out for, some great tips. Anything else to finish us up?
Not that I have.
All right. So if somebody wanted to get a hold of you, Brian Hammer, what's the best way of getting a hold of you?
Probably the easiest way is just to look me up on the internet. I am with the law firm Borland Wallen Wenzel, PC. We are located in Fort Worth, Texas, and our website is www.bwwlaw.com.
That's great. Michael, anything else?
Can you say that again, just in case?
www.bwwlaw.com.
That's great. So we appreciate Brian Hammer being in the podcast. Michael, anything else about what's going on?
That's it. Again, go hopefully we see all you guys at the Texas A&M former chief economist speaker, drawing a blank, Dr. Mark Dotzauer, March 28th. And don't forget about the Old Capital Conference coming up September 13th. That'll be the prices of those tickets will be going up. So we certainly encourage you to come and buy that early, because I think in the next month or so we're going to start jacking the price up.
That sounds great. All right, Brian Hammer, thanks for being in the podcast today. We learned a lot of information concerning purchase sale agreements and the structure of those and some of the gotchas. So thanks for spending some time with us. Michael Becker, always a pleasure. I'm Paul Peebles. Have a great day.
Thanks for listening to the Old Capital Real Estate Investing Podcast. Please join us at oldcapitalpodcast.com to sign up for our weekly email updates. We'll see you next week for another great interview.